Thank you, Madam President. I rise today to support the Democracy is Strengthened by Casting Light on Spending in Elections Act, or the Disclose Act, Senator Schumer's bill to fight the effects of the Citizens United decision. I want to tell Minnesotans listening at home why I support this bill. I want to talk about the problem that this bill addresses and how this bill fixes that problem. And I want to talk about a part of this legislation that came from a bill that I introduced earlier this year. Now, a lot of people don't follow the Supreme Court very closely, so I want to summarize what Citizens United, that decision did. In a nutshell, it allows corporations to spend as much money as they want, whenever they want, in any election in this country. It lets corporations spend their shareholder money to do this. And what's worse, it will allow foreign subsidiaries, wholly owned by foreign governments, to spend just as much money as their American competitors. Madam President, this decision changed our election laws in a radical way. In a single decision, the Supreme Court reversed a century-old legal standard, 2 federal laws, 24 state laws, including a 20-year-old Minnesota law, and 2 of its own decisions, one of which it handed down just 6 years ago. Now, I am not a lawyer and I don't speak Latin, but unless the term stare decisis means overrule stuff, I think we've got an activist court on our hands. But I don't want to talk about legal precedent. I want to talk about how this decision will affect people's everyday lives. I want to talk about the crisis that Citizens United has created for our communities, for the safety of our communities, and for our ability to run them without a permission slip from big business. Let me give you a couple of examples of policies that might never have been enacted if Citizens United had been the law of the land. As of 1965, when America's population was about half as large as it is today, 50,000 people died every year from car accidents. Believe it or not, the auto industry knew full well that it could prevent a large portion of highway deaths just by installing seat belts in every car they sold. But as late as the early 60s, they refused to do that. They said safety doesn't sell, and they lobbied against legislation to require seat belts. Fortunately for all of us, in 1966, Congress passed a law requiring all passengers to have seat belts. By the year 2000, the fatality rate from car accidents had dropped by 71%. Here's another story. In the 1920s, oil companies started adding lead to gasoline. They did this even though they knew that lead was a poison. In fact, 80% of the workers at Standard Oil's very first leaded gas plant died of or got lead poisoning. But this didn't stop oil company representatives from testifying before this very body repeatedly that leaded gasoline and lead pollution in the air were totally safe. That's what they said. But Congress didn't take the bait, and finally in 1970, Congress passed the Clean Air Act and phased out leaded gasoline over the next 2 decades. By 1995, the percentage of children with elevated levels of lead in their blood had dropped by 84%. By 2000, the level of ambient lead in the air had dropped 98%. A lot of people know that the National Traffic and Motor Vehicle Safety Act and the Clean Air Act of 1970 are 2 of the pillars of modern consumer and environmental safety laws. Here's another thing that they have in common. They were both passed about 60 days before midterm elections. Do you think that the seatbelt bill would have been as strong if GM could have run $1 million in attack ads against vulnerable congressmen? by name in the last months before those elections? Do you think that the Clean Air Act would have been so aggressive on lead if Standard Oil could have spent $10 million against lawmakers in Texas? These kind of corporate expenditures would have been made possible by Citizens United. And this is what the Disclose bill will fight. And so here's my point, Madam President. At the end of the day, this bill is not about election law. It's not about campaign finance. It's about seatbelts. It's about clean air in Minnesota and New Hampshire. It's about protecting our right to improve our lives without some corporation saying, no, you can't do that. I want to talk a little bit about how the Disclose Act is going to temper the effects of Citizens United. First of all, the bill will make sure that voters know who is really behind any advocacy group's election ad. Both the head of an advocacy group and its top contributors will have to appear in and approve every ad. These groups will also have to disclose their top donors to the Federal Election Commission. Secondly, the Disclose Act will enhance accountability to shareholders. Corporations will have to disclose their political expenditures in periodic reports. They will have to post this information on their websites. I've worked with Senator Schumer on getting strong disclosure provisions, and so I'm particularly pleased to see these provisions in place. Thirdly, under the Disclose Act, government contractors receiving more than $50,000 will be banned from spending money on our elections. The same goes for recipients of TARP funds who have yet to pay the taxpayers back. This makes sense. If companies are getting taxpayers' money, they shouldn't be able to turn around and spend that same money to tell taxpayers how to vote. Now, I want to talk about a fourth part of the bill, which I think is crucial. As President Obama said in his State of the Union address in January, the Citizens United decision won't just open the floodgates for special interests, it's going to open the floodgates for foreign interests. Under Citizens United, foreign companies with subsidiaries in the United States will be able to use those companies to spend without limit in American elections. As President Obama said, American elections should not be bankrolled by foreign entities. Can't we all agree on that? And that's why that day, a few hours before President Obama stood before the combined houses of Congress, I introduced the American Elections Act, a bill that would close the loopholes in our current laws that allow foreign companies to spend freely in our elections, or that would because of Citizens United. Now, I'm thrilled to say that the Disclose Act contains three of these core provisions, or the core provisions of my act, and I'm so thankful to Senator Schumer for reaching out to work together to include them and for his remarks this morning. He has been a true champion on this issue. So let me summarize these provisions. First, the Disclose Act bars election spending by companies in which a foreign national controls political decision-making or the company's operations. This effectively codifies an existing regulation. Secondly, it bars election spending by companies in which foreign nationals make up a majority of the board of directors. Finally, it bars election spending by companies in which a foreign entity owns a controlling share of stock, defined by the leading Delaware definition for a controlling share, which is 20% stock ownership. Now, this may seem low, but in fact, 31 out of the 32 states that define a controlling share with a number define it as 20% or less. Actually, almost all of them define it as 10%, including Minnesota. They all boil down to this. If a foreign individual, foreign company, or foreign government controls your company should not be spending freely in American elections. American elections should be controlled by Americans. Now, my Republican colleagues are saying that we're fighting a paper tiger here, that we shouldn't be concerned about foreign influence in our elections because the law already prohibits it. Well, the day after President Obama delivered his State of the Union, the minority leader came to the floor to talk about this, and he said that President Obama was wrong and that the law was actually crystal clear on foreign spending, that contrary, this is a quote, contrary to what the president and some of his surrogates in Congress say, foreign persons, corporations, partnerships, associations, organizations, or other combinations of persons are strictly prohibited from any participation in U.S. elections, just as they were prohibited before the Supreme Court's Citizens United decision. Strictly prohibited from any participation. Yet, in fact, because our current laws are vague and out of date, even Citgo, a wholly owned subsidiary of the government of Venezuela, could easily spend freely in our elections because of before Citizens United. Current federal law has three main provisions against federal influence. First, companies must be incorporated and have their principal place of business in the U.S. Citgo's parent company is located in Venezuela, but Citgo itself is organized under the laws of Delaware with its principal place of business in Texas. Citgo passes that test. Second, the Federal Elections Commission requires that any political spending by foreign subsidiaries be drawn from profits made in America. No problem for Citgo. The latest SEC filings, 10K filing, we could obtain show that $625 million in annual profits here in the United States. Citgo passes that test, but it can only spend $625 million on American elections. Finally, current regulations require that all political decision-making for a company be made by Americans, not foreign nationals. You'd think that because Citgo's board of directors has no Americans, it's just for Venezuelan citizens, that it couldn't pass this test. But believe it or not, a July 2000 decision from the Federal Elections Commission said that even this would not disqualify a company as long as a board of directors forms an elections committee with only American members. That company can still spend on elections, even with 100% foreign board membership. So there you have it. If our current laws can't stop Hugo Chavez, who can they stop? Far from expanding the rights of American companies and leaving foreign ones behind a legal firewall, Citizens United has expanded the existing rights of American companies and foreign subsidiaries equally. Both American companies and foreign subsidiaries can now spend as much money as they want, whenever they want, in our elections. We need to act now to protect our elections against foreign governments. We need now to act now to protect our consumer safety and our environmental laws against a corporate veto. We need to act now to pass the Disclose Act, which I am proud to join as an original co-sponsor. Thank you, Madam President, and I yield the floor.